subject to amendment by the legislature. Secondly, because jurisdiction of all courts could be regulated by law, concurrent law, federal law, provincial law, and for purposes of competence, the civil procedure provision included rights of appeal. Ditto, likewise, the power relating to criminal procedure. So that's a totally different situation, you see. Here, where where the Constitution is expressly reverting to the structure of the Government of India Act 1935, where very carefully, the federal court was shielded from the legislator. It's a different thing. जरा kindly इस पर जरा हमें बताइए ना, कुछ हमें इस पे बताइए, समझाइए.
This was my question right from the beginning. ये जो Ordinance 72 के तहत, देखिए Ordinance 72 में 199 आर्टिकल Constitution का है, उसमें अपील की पावर दी against the order of the High Court, whereas Article 199(5) restricts the High Court from calling into question any order of the High Court. उसकी मौजूदगी में लॉ रिफॉर्म ऑर्डिनेंस को 270 में प्रोटेक्शन दी गई. क्या कॉन्स्टिट्यूशन मेकर ने ये नहीं समझा कि ये ठीक लॉ है, बावजूद इसके कि कतगन है आप इसको अपील की रेमेडी दे दो, इसके बावजूद इसके कि 199 में एक रेमेडी सुप्रीम कोर्ट में भी उसको अवेलेबल है. तो इस तरह दो अपील की रेमेडीज मिल गई. तो उस एनालॉजी पे अगर हम जाएं कि कॉन्स्टिट्यूशन मेकर्स तो इससे एग्री कर रही हैं, कोई बात है, by even by ordinance you can provide a remedy,
an appellate right.
Why not through
I'm in respectful agreement with your lordship. Now, the other thing that I wanted to point out is that the civil procedure code, all the different provincial assemblies have amended it, made wholesale amendments to it in the last 5 years, since there's been a bit of a laggard. But the rest of the provinces and the parliament, in case of Islamabad, they made huge changes to the CPC. And those changes have been given effect over the previous civil court rules that were framed by the respective high courts. So to say that any legislative interference in the rule-making power of the courts, of the high courts, or the Supreme Court, to say that that is not permissible, then all those amendments in the CPC will also need to be struck.
All those amendments have been made in the substantive part of the CPC.
Competence to do that for other courts, but not for the Supreme Court. There is a clear distinction.
Lord, but 191 and 202 are in identical terms. The principle applicable here would apply then with equal force.
One question, this is like one Karachi lawyer to another Karachi lawyer. Because you mentioned the Sindh Chief Court rules original side. उसमें एक rule है कि to the extent that the first schedule of the CPC clashes with the Sindh Chief Court rules original side, the original side rules will take precedence, will supersede. So on your theory, would this, whatever rule it is, would this be ultra vires?
Lord, that as far as that was,
on your theory, it would seem that it is ultra vires.
well, that, as far as I can understand, is because of general and special law. The procedure for the CPC is the general, and for the High Court in particular, it's
बात तो competence की है ना, बात तो फिर competence की है. आप कहते हैं कि जी it's the reverse. The competence is the reverse. Law can override the rules, but not vice versa. मैं आपको एक मिसाल दे रहा हूँ. कब आए थे हमारे ये original side 1944 के है ना?
1930
rules है original side.
I've forgotten the exact
lawyers, Zuhairi Saab.
I think Abid Saab might remember.
Anyway, that's on the lighter side.
आप कितना टाइम ले रहे हैं आप?
Sir, I'm just trying to wrap up.
जी बताएं.
जी sir.
क्योंकि there is a mutiny against the master. Murmurings of a mutiny against the master.
My lord, my colleagues who are waiting have also assured me of great retribution if I don't wrap up quickly.
You know, but there may be a pen down strike. You cited the example of Nepal. So a similar strike has been threatened, that you are the last counsel for the day and the rest we'll hear tomorrow, inshallah, at 11:30. So please wrap it up now.
I'm wrapping up, sir. Sir, एक और चीज मैं जरा दिखाना चाह रहा था. If your lordship sees, जहाँ law का लफ्ज है, because an expansive interpretation of law was urged. If your lordship will see, जो 175(1) की power है, such other courts as may be established, and that is why we have to look at the context of each of the provisions, such as other courts as may be established by law. Obviously, over there, the law could not be judicial precedents of this court. While law is normally has a, now similarly 175(2) में फिर उसी तरह सर 192 में जो power है to that the high court shall be have as many judges as may be prescribed by law, again it could not be law that is prescribed by any judgment. So the argument that 191 has to be treated as this grand provision that includes everything and rules and bylaws and all that, I would humbly submit that that is not borne out.
The
from
law
the
is
context
made
of
under
the-
Article 175(2). The pursuant to Article 175(2), this law has been made. जो उसमें लिखा हुआ है, read with Article 191.
बिल्कुल. अब सर, now I'll
ये
come.
जो इसमें आप 2 को पढ़ेंगे ना, इसको 187 के साथ पढ़िए. 187 में इसका रेफरेंस है.
जी सर.
187 पढ़िए.
Subject to clause 2 of Article 175, it recognizes
ये
that.
jurisdiction confer जो हो रहा है ना 175(2) का, it is read with Article 187 as well. उसी का रेफरेंस है वहाँ.
बिल्कुल.
कि जो भी सुप्रीम कोर्ट पावर एक्सरसाइज करेगा, that is subject to Article 175 sub Article 2.
बिल्कुल. I agree, sir. सर, एक और जहां तक इंट्रा कोर्ट अपील की वो जो सेक्शन 5 वाली इशू है, I just wanted to briefly point out the occasions where Parliament has created an additional appellate jurisdiction on this court over and above what is written in 185, Section 9, 155, and 202 of the Election Act, Section 44 of the Competition Act, Section 48 of the Legal Practitioners and
What
Bar
are you
Council.
referring to, sorry?
The power of Parliament to confer an additional appellate jurisdiction on this court, which is not anywhere mentioned in 185. 185 talks of only orders of the High Court, but they have created appeals coming from different forums, and those, the constitutionality of that has never been.
Including contempt of court.
Yes, sir. And finally, Section 19 of
Intra-court
the
appeal.
contempt of court.
Contempt of
So-
court was the ordinance. It was saved by 270, and it was saved in the 18th Amendment.
Yes, sir.
So that's a different.
But
category.
again, what I would urge is that the savings is retrospective validation, as this court has held that the Article 268 to up till 270, AAA, etc. They don't mean that a law that is saved can continue despite being in violation of some constitutional provision. So the Contempt of Court Act might have been saved because it was
Salahuddin,
promulgated
which was
by-
the third law, election competition, which was the third one?
Sir, Section 48 of the Legal Practitioners and Bar Councils Act.
So in Section 54 of the Land Acquisition Act also.
Ji, sir, bilkul, bilkul. That is an example, and that is an example of a provisional provincial law creating.
आपने कहीं लिखा, आपने सारी चीजें लिखी हैं कहीं?
जी सर,
अगर नहीं लिखी हैं, ग्लेस दे दीजिएगा.
जी बिल्कुल सर. They are in my concise statement.
Hey, if I could just ask a question, is there no difference between creating a right of appeal to the Supreme Court from some subordinate court's order or forum's order, as opposed to creating a right of appeal at the Supreme Court from an order of the Supreme Court itself? As I see it, there is a difference. So the examples that you give are a little different. This is bringing a right of appeal to the Supreme Court, whereas we are looking at the right of appeal against an order of the Supreme Court in a jurisdiction given and spelled out by the Constitution. So the question here is that if the Constitution has provided for a right of appeal or has not provided for the right of appeal, can, by way of statute, that right be created in the Constitution? I mean, there is a difference. Looking at laws which provide a right to the Supreme Court is something a little different than what this case is about over here. And these examples, at least I don't understand how these examples would help your case over here.
The law that specifically creates an intra-court appeal is the contempt of court ordinance.
Yes,
Section 90, it creates an intra-court appeal from this court to a larger bench of this court. So that is a precise.
That is a precise, but there is an explanation and a judgment that deals with that specifically, which again doesn't answer the question that we have asked you again on competence, and I'm asking you how an amendment to the Constitution can be made, or a provision which is not given in the Constitution can be made through ordinary law.
Your leadership will appreciate that Article 204 of the Constitution does not create any right of appeal. It only allows Parliament to regulate the punishment of contempt.
And
In
this
that
word,
regulatory power and appeal
wait
under
second,
Section
this
19
word
has been-
regulate has been explained that it means conferring of some form of rule-making legislative power. There are judgments to that effect. So the word regulate has been used. So election key provision may the word regulated by law is used, as Mr. Bhandari had pointed out.
So if
Again,
that-
it is a little different.
my humble submission would be-
Salahuddin, ये बताइए, give an example. How can the jurisdiction under Article 184(3) उसकी expansion कैसे हो?
Yes,
You see, this is a precise question. Secondly, there are various jurisdictions of the Supreme Court. It is not that they all separately would be expanded. That is why, you see, जो settled principles हैं, whether वो हमारी judgments हैं, that these entries have to be interpreted liberally and broadly. But सिर्फ इतना बता दीजिएगा, give one example how through law can Article 184(3) jurisdiction उसकी expansion कैसे होगी वो बता दीजिए.
Sir, मेरी submission, and this will be my last submission on this issue of appeal, is that even if a presumption of finality is attached to the 185 appellate jurisdiction, and I think that is quite reasonable, it cannot just keep in endless loops of appeals over there. A presumption of finality exists for appellate jurisdiction. That presumption is not there for the exercise of original jurisdiction by this court. And the reason for that is, sir,
I didn't understand.
sir, even if it is said that 185 की जो appellate jurisdiction है, there is a presumption of finality attaching to it, because of which Parliament cannot create an additional statutory appeal over and above an appellate case already decided by this court. That presumption can certainly not be applied to the exercise of original jurisdiction under 184(3).
Okay.
And the reasoning, one submission that I'll make on that point is, sir, and it carries on from what Mr. Zahid Ibrahim had said. Article 2A and वो जो दो judgment cite की थी, Federation of Pakistan versus Public at Large, etc. The right of appeal is part of the injunctions of Islam. Now, if you have two possible constitutional interpretations, one allows the Parliament to create a right of appeal. One says that no, Parliament cannot create a right of appeal. The interpretation that is in consonance with the principles of Islam is to be preferred.
Is it enlargement of the existing jurisdiction?
My lord, enlargement ke hawale se, I have a very plain and simple understanding. Enlargement means to make larger. It can mean that the scope of an existing jurisdiction is made broader and deeper. It can mean that new things are added to that jurisdiction. It is to be treated, it is a legislative entry after all. It is to be given an expansive meaning.
Mr. Salahuddin, in right of appeal, what do you say about the retrospective effect to the right of appeal?
Jesus, that is.
And there is no end to this. There is no cutoff date.
My lord, that
It
is.
will start from
Lekin again-
1973, from the date of the Constitution, or what?
Lord, I'm going to take a slightly cowardly way here.
नहीं, लेकिन
There is one
ये
interpretation that your
इसके
lordship.
साथ ये बता दीजिएगा, क्या जिन केसेस में रिव्यू ऑलरेडी एक्सरसाइज हो चुकी है, will they be also covered?
No, sir. There will be. Now, one interpretation that can be taken is it's a remedial statute, etc. It's meant to confer, and then if it's remedial and retrospective effect back to 1975. The other more limited interpretation that could be taken is, sir, that it is only meant to open the door for those cases that were decided within the 30-day limitation period mentioned in section 5. So it would apply to those cases that had been decided 30 days prior to the promulgation of the act. That is the limited retrospectivity.
This is not the interpretation of this law. This is prior to commencement of this act. This is open-ended, you see. This is one of the interpretation which you are giving. Within 1 month, jo decide hui hai, that can be taken into
But
consideration.
to save the constitutionality of the law, your lordships are empowered to give it a limited reading or even read it down to that. Now, two more things and I'll just wrap up, sir.
You were on the last thing now. I said you were on the last thing.
Yes, sir. These are just for the specific provisions, the issues with the specific provisions that have been raised. I'll run through them, sir. एक बात की गई थी, sir, कि the gatekeeping imposed by section 3, that the committee is an administrative committee. It gatekeeps the exercise of judicial powers by this court. Now, 1 month ago, sir, I filed a petition for the Bar Council on challenging the amendments to Official Secrets Act and the Army Act. The registrar returned it on the basis that this is not of public importance and no question of fundamental rights is involved. That appeal will lie, and it's an appeal conferred by the procedural rules. It's an administrative appeal. It will lie to a single judge of this court, and he may accept it or reject it, and I'll have no remedy against that. Now, if the registrar with the single judge in chambers can act as an administrative gatekeeper over the exercise of judicial power under 184(3), I fail to understand why a committee cannot do so.
The right of appeal lies to the chamber.
Yes.
In case of registrar, if the committee rejects, then where the appeal lies.
Sir, but your lordship will appreciate
Single judge.
The right of appeal to the single judge in chamber is not a
No, it is
judicial
Article
appeal. It's only an
184(3).
administrative appeal.
One Article 184(3), the committee will decide whether it is a case of public importance or not. In case they reject, in case registrar rejects the appeal, then the appeal lies in chamber to a single judge of the Supreme Court. ठीक है? यहाँ पे अगर कमेटी ने रिजेक्ट कर दिया, उसके बाद फिर वो कोई रास्ता नहीं है उसके लिए. वो फिर the committee has rejected, then there is no right of appeal unless we will read it down.
Yes, that is.
आप कह रहे हैं वहां पे एक जज है, यहाँ पे 2-3 है, तो आपका क्या कंटेंशन है कि
I don't, and perhaps there is one logic behind it, because Article 199 की जो jurisdiction है, that is available. The remedy is available to me as of right if I am an aggrieved person, etc. जो 184(3) की जो jurisdiction है, that is a discretionary.
नहीं तो यहाँ जो अपील आएगी ना, it's not an appeal deciding a list. It is only deciding the competence whether it should be heard or not. Otherwise, the list will remain alive. You can take it in a suit, you can take it in a writ jurisdiction. I don't know, whichever way you want to take it, but we don't kill the list. I mean, it's okay.
Exactly.
You don't meet the test in our opinion. That opinion, your point is that if one judge can get it wrong, the registrar gets wrong, you have it before one judge. Here the 3 judges get it wrong. So,
and because your lordship will appreciate that when I come in 184(3), I can show to your lordships that I have. Sir, let me just complete this and then I can show to your lordships that I have a case of great public importance.
How are you
It
reading
engages
this right in
fundamental
section
rights,
5?
But your lordships may still
How are
decide not to
you- how are
entertain it and send me back to the High Court.
How are you reading this right in section 5? Section 5 says, by an order of a bench exercising jurisdiction under 184(3). So how are you reading the right under section 3, that if you are denied, that case is not fixed, that appeal will come under section 5? It doesn't come under section 5.
I'm not reading that, Your Ladyship. I was talking about the fact that an administrative gatekeeper was present under the old system for 43 years, and it is present.
Mr.
Salahuddin, Mr.
There
Salahuddin.
is an administrative power
Please
being
read section
exercised.
3. Please read.
Any matter invoking exercise of original jurisdiction under clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under section 2 for examination. And if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by chapter 1 of part
Please
2
stop here. There are two conditions precedent. One is case of public importance, and the other is the infringement of the fundamental rights. And if this is decided by the committee, and finally it is said that it is a not fit case to be entertained under Article 184(3) of the Constitution, and the person goes to High Court under Article 199, and thereafter, if appeal comes to the Supreme Court, that would be against the order of the High Court under Article 185. It would not prejudice the case of that person, and because of the reason that already opinion has been given, three senior judges of the Supreme Court.
Lord, my humble submission is it would not prejudice the case of the petitioner because it is merely an administrative decision. It is not just like the single judge in chamber.
On judicial
His
side,
order has no judicial precedent.